Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of family law, that too in relation to child custody matters. To know more about it, please watch the video fully.
Versus State of Gujarat and others, pronounced on 9th June 2022. The Supreme Court has held that income, age, bigger family cannot be the sole criteria to tilt balance in child custody cases. The fact of the case would be that the child and his parents were staying happily. Unfortunately, both the parents died during the second wave of COVID-19. While the parents of the child were infected with COVID-19, the minor was residing with respondent number 4, that is the maternal aunt. The appellant, the paternal grandfather, approached the High Court by way of the present writ of habeas corpus, alleging that the maternal aunt is not allowing them to enter the house of his son and daughter-in-law and to take belongings of the child. It was also alleged that the appellant is not even permitted to meet the child. Therefore, the appellant sought custody of the minor child aged 5 years. However, the High Court gave the custody of the minor to the maternal aunt. Being aggrieved, the paternal grandfather approached the Supreme Court with allegation that merely because the appellant is aged 71 years and his wife, the paternal grandmother is aged 3 years, and therefore to presume that the paternal grandparents would not be in a position to take better care of the grandson cannot be accepted. The appellant also alleged that merely because respondent number 4 is having a bigger family, there cannot be any presumption that they will take better care of the grandson of the appellant. The Supreme Court has held that from the impugned judgment and order passed by the High Court and while handing over the custody of the minor to the maternal aunt, what have been weighed with the High Court is that the paternal grandparents are in old age, against which maternal aunt is aged 46 years. That she has a bigger family, that the appellant is a retired government servant depending upon the pension, against which the maternal aunt is a government employee, and therefore she will be in a better position to take care of the minor. Therefore, the High Court opined that it will be in the larger interest and welfare of the child that the custody is handed over to the maternal aunt. However, at the same time, it is required to be noted that the child was shown his inclination to stay with the parental grandparents, so recorded in one of the orders. It is to be noted that the custody of the minor remained with the grandfather pursuant to the interim order passed by the High Court. Nothing is observed by the High Court that during the interim custody period, the paternal grandparents did not take proper care of the minor. There was no grievance made by the minor. On the contrary, and as observed herein above, the minor has shown his willingness to stay with the appellant. Nothing is observed by the High Court that during the interim custody period, the paternal grandparents acted detrimental to the interest of the minor and or they did not take proper care. Further, the reasons assigned by the High Court while handing over the custody of the minor to the maternal aunt may be relevant but not German. There cannot be any presumption that the maternal aunt, being unmarried, having an independent income, younger than the paternal grandparents and having a bigger family, would take better care than the paternal grandparents. In our society, still, paternal grandparents would always take better care of their grandson. One should not doubt the capacity and or ability of the paternal grandparents to take care of their grandson. Therefore, income and or the age and or the bigger family cannot be the sole criteria to tilt the balance and not to give the custody of the grandson to the paternal grandparents. Thus, High Court committed an error in not handing over and or continuing the custody of the grandson to the paternal grandparents and to give custody to the maternal aunt. If the balance is to be struck between the paternal grandparents and maternal aunt, For the reasons stated above, the balance would certainly tilt in favor of the paternal grandparents. The interim judgment and order passed by the High Court handing over the custody of the minor to the maternal aunt rather than handing over the custody of the minor to the paternal grandfather is unsustainable, and the same deserves to be quashed and set aside, and is accordingly quashed and set aside. However, it is also made clear that the present order shall subject to the final outcome of the proceedings under Section 7 of the Guardian and Wards Act pending before the competent court. This court directs that the custody of minor be continued with the paternal grandparents, who are directed to take care of minor. The appellant is also directed to ensure the better education of the child in a school at Ahmedabad. However, the maternal aunt shall have visitations right, and this court expects the appellants to provide a right to meet the child on regular basis, preferably once in a month, subject to the convenience of the child. It is also further observed that during the vacation and or holidays, the appellant may permit the child to visit and stay with the maternal aunt. Of course, subject to wishes and convenience of the child, and it may not adversely affect the interest of the child, including his education and even the extracurricular activities. It is also expected to have video calling between the child and maternal aunt on regular basis. This court requests both paternal grandparents and maternal aunt and her family to act jointly and cordially and have cordial relations which shall be in larger interest of the minor.